Hey, stop right there. Excuse me? ID. Now, let me see some identification. Can you tell me what this is about? You fit a description. What description? I'm asking the questions here. Comply right now or you're going in cuffs. I work in this building. I have every right to be here.
The officer had no idea the command he just gave would cost him everything. The man standing in front of him wasn't a threat, wasn't a suspect, wasn't even someone who owed him an explanation. But Officer Ryan Kowalski couldn't see that. All he saw was what he expected to see. And the body cam on his chest was recording every second of the biggest mistake of his career. It was 6:45 p.m. on a Wednesday evening in downtown's Federal Courthouse District. The spring sun had just dipped below the skyline, casting long shadows across the multi-level parking structure that served the imposing granite building where justice was administered daily. Judge Marcus Whitmore, a 15-year veteran of the federal bench, was doing what he'd done hundreds of times before leaving work late after a particularly grueling sentencing hearing. He'd already removed his judicial robe, changed into business casual slacks and a button-down shirt, and carried his worn leather briefcase containing case files he'd review at home. At 52 years old, Judge Whitmore had presided over everything from white-collar fraud to civil rights violations. He was respected, meticulous, and known among attorneys for his fairness and command of constitutional law. Officer Ryan Kowalski, 34, had been patrolling the courthouse area for the past 2 hours. An 8-year veteran of the police department, he'd received a briefing that morning about recent car break-ins in the downtown parking structures. Professional types leaving their vehicles during work hours made easy targets for thieves looking for laptops and valuables. When Kowalski saw a well-dressed black man walking purposefully toward a late-model Mercedes sedan in the dimly lit parking level, something in his mind clicked. The man didn't fit, couldn't possibly belong there. Not at this hour, not in this area. It was a judgment made in seconds, a judgment based entirely on appearance, and it was completely catastrophically wrong. Officer, I'd be happy to cooperate, but I need to know what's the reason for this stop. The reason is, I'm asking. That's all the reason you need. I work in this building. I have every right to be here. I'm simply going to my vehicle. Sure you do. Anyone can say that. I need to see identification. Right now. The judge spoke slowly, deliberately. Officer, I'm going to reach for my wallet. It's in my back right pocket. I'm telling you this so there's no confusion. His hand moved with careful precision toward his pocket. Stop moving. I said, keep your hands where I can see them. The officer's hand dropped to his weapon, not drawing it. Not yet. But the message was clear. Judge Whitmore froze. His hand hovered 6 inches from his pocket. The leather briefcase in his left hand suddenly felt like evidence of guilt rather than a day's work. Officer, you just asked for my ID. I was retrieving it. Don't tell me what I asked for. Put both hands on the vehicle. Now. This was Officer Kowalski's first mistake. Not the stop itself, though that would matter later. Not even the aggressive tone, though that too would be scrutinized. The mistake was answering a reasonable question with ego instead of procedure, treating a simple request for clarity as a challenge to his authority, escalating instead of explaining. In those 10 seconds, what could have been a brief, embarrassing misunderstanding became something else entirely. It became evidence. Was the officer justified in his suspicion, or was something else at play? Drop your thoughts in the comments. Judge Whitmore's voice remained steady, calm, the tone he used in his courtroom when an attorney was about to make a procedural error. Officer, unless you have reasonable, articulable suspicion that I've committed, am committing, or am about to commit a crime, I'm not required to identify myself under the Fourth Amendment. Officer Kowalski's eyes narrowed. Oh, we got a lawyer here? That what you are? Some downtown lawyer thinks he knows the law better than me? I'm familiar with Terry versus Ohio. I'm asking you respectfully, what specific criminal activity do you suspect me of? What I suspect is you're in a restricted parking area after hours, refusing to cooperate with a lawful order and getting real smart with me real fast. This is public parking for the federal courthouse. I have security clearance. My credentials are in my briefcase. I'm offering to show them to you. Here's what the law actually said, and what Officer Kowalski should have known. Terry v. Ohio, decided in 1968, established that police officers may conduct a brief investigative stop when they have reasonable suspicion of criminal activity. But that suspicion must be based on specific, articulable facts, not hunches, not appearance, not the neighborhood someone happens to be in. Walking to your own car in a public parking structure isn't a crime. Being well dressed in a business district isn't suspicious. And calmly citing constitutional law isn't obstruction. But Officer Kowalski heard legal language and interpreted it as resistance. I'm done talking. Turn around, hands behind your back. Officer Kowalski, your name is visible on your badge. I'm asking you to reconsider this. You're making a mistake. The only mistake here is you thinking you can talk your way out of this. Hands behind your back. Last warning. The judge complied because he knew what happened to people who didn't, and he knew his skin color made that math even simpler. The handcuffs clicked shut around Judge Whitmore's wrists. Metal, cold, tight enough to leave marks. Officer, before this goes any further, I need you to listen carefully. I am a federal judge. My credentials are in my briefcase. I'm asking you to verify my identity before you compound this situation. Officer Kowalski actually laughed. Not a friendly laugh, a dismissive one. Sure you are, and I'm the chief of police. You know how many people try to talk their way out of arrest? Come on. Officer Kowalski, your badge number is 743. I can see it clearly. I'm giving you an opportunity to check who I am. After that, this becomes your choice. The officer's expression hardened. Are you threatening me? Because that sounds like threatening a police officer. That's obstruction. Congratulations, you just added a charge. A second patrol car pulled into the parking level. Officer Martinez, Kowalski's partner for the evening, stepped out. His body cam was also recording. Ryan, what have we got? Suspicious person in restricted area, failure to identify, obstruction, possible trespassing. Guy's being real difficult. Officer Martinez looked at Judge Whitmore, a well-dressed, middle-aged man in handcuffs, standing calmly next to a Mercedes sedan, a leather briefcase on the ground beside him. Something in Martinez's expression shifted. Uncertainty. But he didn't intervene. You want me to transport? Nah, I got it. Just bag his property. Officer Martinez picked up the briefcase. It wasn't locked. He opened it. Inside, case files, legal documents, and a federal courthouse security badge with a photo and clear text. Honorable Marcus J. Whitmore, United States District Court, federal judge. Martinez froze. Ryan, you should see this. Kowalski waved him off without looking. Probably stolen. People steal IDs all the time. Bag it. Ryan, I really think. I said bag it, Martinez. I'm handling this. Judge Whitmore said nothing. He stood with his hands cuffed behind his back, watching two officers decide whether procedure or pride would win. Pride won. Officer Kowalski walked Judge Marcus Whitmore, a 15-year federal judicial veteran, to the patrol car, placed a hand on his head, and guided him into the back seat. The door closed, and the point of no return passed in silence. 20 minutes later, at the downtown precinct, Desk Sergeant Linda Chen processed the incoming suspect. Standard protocol, name, date of birth, address. Run the information through the database. She typed, Marcus J. Whitmore. The computer screen flashed red. Federal Judiciary, Judicial Officer, do not detain without supervisory approval. Notify court security immediately. Sergeant Chen's face went pale. She looked up at Officer Kowalski, who stood filling out paperwork. Ryan, get in here. Now? I'm kinda busy, Sarge. Now. He walked over. She turned the computer screen toward him. The color drained from his face. That can't be right. Judge Whitmore, still in handcuffs, sat calmly on the bench. He spoke quietly. I tried to tell you. Sergeant Chen's hands moved to her radio, then stopped. She looked at Kowalski, then at the judge, then back at the screen. Remove those handcuffs, right now. Sarge, I didn't ask for an explanation. Remove. The handcuffs. Officer Kowalski's hands shook as he reached for his keys. He fumbled with them, dropped them once, picked them up. He approached Judge Whitmore. Leave them on. Kowalski stopped. I want this documented exactly as it happened. Every second I spent in these handcuffs. Every moment I was detained. Leave them on until your supervisor arrives. Your Honor, I didn't know. You didn't ask. The precinct went silent. Other officers who'd been milling around, doing paperwork, drinking coffee, they all stopped, stared. The same badge Officer Kowalski had mocked as probably stolen was now the only thing in the room that mattered, and everyone knew it. Officer Kowalski stood 3 feet from Judge Whitmore, unable to meet his eyes. He tried again. Your Honor, I was responding to reports of car break-ins, and I thought, I didn't realize. You didn't realize what, officer? That I worked there? That I had every right to be in that parking structure? Or that treating someone with respect might have avoided all of this? Silence. Officer Martinez had backed away, standing near the door, his own face ashen. He'd seen the ID. He tried to say something, but he hadn't pushed, hadn't insisted. He was complicit through silence. Sergeant Chen had already begun reviewing the body cam footage on her desktop monitor, headphones on. Every few seconds, her expression tightened. A wince here, a head shake there. Every dismissive comment, every ignored explanation, every escalation, all captured in high definition with time-stamped audio. Officer Kowalski finally removed the handcuffs. Judge Whitmore massaged his wrist slowly. Red marks encircled both, the skin slightly indented where the metal had pressed against bone. No one spoke. The judge's voice, when it came, carried no anger, just exhaustion. How many others, Officer Kowalski? How many people who weren't judges, who didn't have credentials to prove they belong, who couldn't cite case law? How many of them are in the system right now because you made the same assumptions about them that you made about me tonight? Officer Kowalski had no answer because there was no good answer to give. Within 30 minutes, Police Chief Douglas Raymond received the call at home. He was in his personal vehicle headed to the precinct 12 minutes later. By the time he arrived, the station felt like a funeral. Officers moved quietly, avoiding eye contact, especially with Kowalski, who sat alone in a corner office, his body cam already surrendered to Sergeant Chen. Chief Raymond entered the precinct, still in civilian clothes, and went directly to Judge Whitmore. The apology was immediate, personal, and unreserved. Your Honor, on behalf of this department and myself personally, I am deeply sorry for what happened tonight. There is no excuse. None. Judge Whitmore stood. They did not shake hands. Chief Raymond, I'm not interested in apologies right now. I'm interested in accountability. I want the body cam footage preserved. I want a full internal affairs investigation, and I want to know what policies allow this to happen. You have my word, all of it. I'm declining to press criminal charges tonight, but I'm reserving all civil remedies. Your department will be hearing from my attorney. Officer Kowalski was placed on immediate administrative leave, not suspension leave, pending investigation, with pay. The body cam footage was downloaded, secured, and flagged as evidence, both Kowalski's and Martinez's cameras. Every angle, every second. Officer Martinez was separated and taken to a different room for an independent interview. He'd seen the credentials. He'd hesitated. He hadn't acted. Failure to intervene would be added to his investigation file. Judge Whitmore's briefcase was returned to him. Sergeant Chen had photographed every item inside as documentation. Legal files, pens, reading glasses, a granola bar, and the federal security credentials that should have ended this before it began. At 11:47 p.m., Judge Marcus Whitmore walked out of the precinct, got into his Mercedes, and drove home, 3 hours after he'd simply tried to go to his car. By 6 a.m. the next morning, local news had the story. Someone at the precinct, someone appalled by what they'd witnessed, had leaked it. Officer suspended after arresting federal judge in courthouse parking lot ran across the morning broadcast. The police union issued a statement by 9 a.m. We are aware of the incident and are awaiting the results of the investigation before commenting further. Translation: they had no defense, and they knew it. The internal affairs investigation moved quickly. Too much evidence. Too clear a violation. Too public a figure. But what they found went deeper than one bad stop. Officer Ryan Kowalski had been with the department for 8 years. In that time, he'd accumulated 7 civilian complaints. All 7 had been dismissed, or marked not sustained. When internal affairs pulled the files, a pattern emerged. 5 of the 7 complaints came from Black or Latino civilians. The common thread: Suspicious persons stopped in professional districts, business areas, parking structures near office buildings. One case from 2 years earlier, a black attorney stopped outside his own law firm at 7:30 p.m., accused of loitering. The attorney had provided his bar card, his business card, and his office key. Officer Kowalski had still detained him for 20 minutes, running his ID for warrants. Nothing found. Attorney released, complaint filed, complaint dismissed, officer acted within policy. Another case, a Latino doctor stopped in the hospital parking lot during a night shift, accused of being in a high theft area. The doctor had shown his hospital credentials immediately. Officer Kowalski insisted on running his driver's license anyway. Again, nothing. Again, released. Again, complaint, filed, and dismissed. The department's review board had never flagged a pattern because each case was reviewed individually. Complaints handled in isolation never revealed the through line. But with Judge Whitmore's case forcing scrutiny, the connections became impossible to ignore. The body cam footage from the Whitmore incident was immediately flagged for training purposes, not as an example of good police work, as a case study in implicit bias, escalation, and the consequences of assumptions. 10 days after Judge Whitmore's arrest, the Department of Justice Civil Rights Division opened a preliminary inquiry, not just into Kowalski, into the department's pattern and practice of stops in minority communities. The ACLU of the state filed an amicus brief supporting a broader investigation, citing Whitmore's case as evidence of systemic issues. Community advocacy groups came forward with additional complaints, stories that had been dismissed, ignored, or never formally filed because people didn't think anyone would listen. Suddenly, they had a case that made people listen. What happened to Judge Marcus Whitmore wasn't unique. It was simply the first time the person on the other end had the power, the platform, and the legal expertise to make sure it couldn't be swept away. The 60-day internal affairs investigation concluded with a 47-page report. The findings were damning. Asterisk, unlawful stop without reasonable suspicion. Asterisk, false arrest without probable cause. Asterisk, Fourth Amendment violation. Asterisk, failure to de-escalate when provided with exculpatory information. Asterisk, abuse of authority. Asterisk, conduct unbecoming an officer. Recommendation, termination. Officer Kowalski requested a review board hearing. It was granted. He appeared with union representation and an attorney. The hearing lasted 4 hours. The body cam footage was played in full. Every second of the parking lot encounter, every dismissive comment, every ignored explanation. The moment Martinez found the credentials and Kowalski waved him off, the board deliberated for 90 minutes. Termination upheld. On the criminal side, the district attorney's office reviewed the case for possible charges: false arrest, deprivation of rights under color of law, official misconduct. They declined to prosecute. Qualified immunity, the legal doctrine that shields officers from criminal liability unless they violate clearly established rights, protected Kowalski from prosecution. His attorney argued he'd made a good faith mistake in judgment. The DA knew that in court, that argument might work. Judge Whitmore expected this. He'd seen it dozens of times from the bench. Officers rarely face criminal charges, even in clear-cut cases, which was exactly why he'd reserved his civil remedies. 8 weeks after his arrest, Judge Marcus Whitmore filed a federal civil rights lawsuit in the United States District Court. Marcus J. Whitmore v. Officer Ryan Kowalski and the City of Redacted. The claims: asterisk, unlawful seizure in violation of the Fourth Amendment. Asterisk, false arrest. Asterisk, racial profiling. Asterisk, deprivation of rights under the 14th Amendment Equal Protection Clause. Asterisk, municipal liability for failure to train and supervise, filed under 42 U.S.C. Section 1983, the federal statute that allows citizens to sue government officials for constitutional violations. Defendants Officer Ryan Kowalski, individually, and the city as his employer. The city's legal team watched the body cam footage. They read the internal affairs report. They consulted with their liability insurers, and they made a decision: settle. Do not fight this in court. A trial will be a public relations disaster. A federal judge on the witness stand describing being handcuffed in his own courthouse parking lot. Media coverage. community outrage, potential punitive damages if a jury got angry enough. Settlement negotiations began in month 4. The city offered $250,000 initially. Judge Whitmore's attorney countered with $750,000. They met in the middle. The settlement agreement included standard language. The city admits no wrongdoing or liability. This settlement is made to avoid the cost and uncertainty of litigation, but it also included policy reforms. Asterisk, mandatory bias training for all officers. Asterisk, revised, stop, and identify policies requiring articulable suspicion. Asterisk, body cam footage review protocols. Asterisk, supervisory notification for all courthouse area stops. Officer Kowalski's personal financial contribution to the settlement, $0. The city indemnified him completely, as it does for all officers acting within the scope of employment. The taxpayers covered the full $525,000. Kowalski's professional future collapsed anyway. His law enforcement certification was reviewed by the state's Peace Officer Standards and Training Commission. Decertification was recommended based on the termination findings. The commission stopped short of full decertification. He could theoretically work in another state, but flagged his file permanently. He applied for security positions, private firms, courthouses, corporate campuses. Background checks revealed the case. Every time. His LinkedIn profile, which had once listed 8 years of dedicated public service, was deleted after reporters found it and media attention intensified. The body cam footage, released via public records request, went viral. 4.3 million views in the first week. National media picked it up. CNN legal analysts broke down the Fourth Amendment violations. MSNBC ran segments on qualified immunity and police accountability. It became a case study in law school constitutional law classes. And Judge Marcus Whitmore gave exactly one interview to a legal podcast 3 months after the settlement. His quote, "This was never about revenge. It was about accountability. Not just for me, but for everyone who's been stopped, searched, or arrested because someone made an assumption about who they were based on what they looked like." Judge Marcus Whitmore returned to the federal bench. He continued presiding over cases, fraud, civil rights violations, drug trafficking, immigration matters, the full spectrum of federal jurisdiction, but colleagues noticed small changes. In sentencing hearings where police testimony was key, he asked more pointed questions. Not hostile, just thorough. "Officer, what made you suspect my client was armed? Can you articulate what specific behavior seemed suspicious? How long have you patrolled that neighborhood? And how many stops have you made there in the past year?" He began accepting speaking invitations, judicial conferences, law school panels, police academy training sessions. His topic, implicit bias in law enforcement encounters. He never named Officer Kowalski in these talks, never made it personal. He made it systemic. Officer Kowalski rebuilt a life outside law enforcement. He avoided media, stayed off social media entirely, found work eventually outside the public eye. The $525,000 became a talking point in police reform circles. Some argued individual officers should contribute financially to settlements. That full indemnification removed accountability. Others said it would bankrupt working officers and make recruiting impossible. The debate continues. But beneath the policy arguments lives a simpler question. How many stops like this happen every day to people without power, without legal expertise, without credentials that force the system to listen? How many people are sitting in jail cells right now because an officer made the same assumptions about them that Kowalski made about Judge Whitmore, but they didn't have a federal security badge to prove them wrong? The body cam that was supposed to protect Officer Kowalski became the evidence that ended his career. Technology as a double-edged sword. It can protect, it can expose. It all depends on what you're doing when it's recording. Power unchecked becomes power abused. And sometimes, just sometimes, the person being checked has more power than you realize. Not because of their title, but because they know their rights and they refuse to let a violation go unanswered. So here's the question. Should Officer Kowalski have been criminally charged, or was termination and the lawsuit enough? If you were Judge Whitmore, would you have handled this differently? Pressed charges, settled for less, made it more public? And the bigger question, have you or someone you know experienced something similar? A stop that felt wrong? An officer who made assumptions based on appearance? Share your story in the comments. These conversations matter. If this story matters to you, if accountability matters to you, hit that subscribe button. We don't just cover cases where accountability is promised. We cover cases where it actually happens. Turn on notifications, because justice delayed might be justice denied, but justice documented is justice delivered. Next video, we're covering the case of an off-duty firefighter wrongfully detained for fitting a description and how his dashcam footage led to a department-wide policy overhaul. Thanks for watching. See you in the next one.